Please be seated. The next case on the docket is Florida Farm Bureau versus Mathis. Counsel.
Good morning. May it please the Court. My name is Elliot Kula. I'm with the Greenberg-Twarg Law Firm. With me today is Mark Upton. We're here on behalf of the appellants, Florida Farm. I'd like to reserve 5 minutes of my time for rebuttal. The legal question presented today is whether an insured is entitled to a double recovery for a single total loss of a dwelling by first turning to the flood insurer to recover the policy limits for the total loss due to flood damage, recovering that policy limits, and then turning to the wind insurer and claiming a total loss for wind damage, the same dwelling.
I'd like to sort of start by sort of a threshold matter is discuss the rule of law established by the Supreme Court in Cox. Because as I understand Cox, and you're really the expert, we don't specialize in this, but we get cases frequently now still. Under the value policy law, the insurer is not liable for the full face amount of the policy if the insured peril didn't cause the total loss. That's one principle in Cox, correct? And Cox would apply only where there are two perils under a policy, one covered, one excluded, that caused the damage, and the covered peril didn't cause a total loss. Does Cox, in a situation where you have two perils causing loss, does Cox require that there be some sort of balance and determination made so that you come up with a percentage of loss on each peril? Do you follow what I'm saying?
I do, and that is absolutely correct under Cox, which is why we believe that Cox is dispositive of this case. This case doesn't break any new ground.
So Cox, more or less, adopted a rule of law that was very similar to the 2005 statute.
That's correct. That's exactly correct. And Cox answers the question. Although the facts in Cox were slightly different than the facts in this case, the principles announced in Cox are fully dispositive of this case.
But if that's right, isn't it necessary in any case with two perils causing the loss that the trial of those must consider which peril caused which damage? And the ruling here on the motion in limine precluded that, didn't it?
It did. The ruling in the motion in limine precluded that. That evidence should have come in its entirety. As the trial unfolded in this case...
Does your appeal include the ruling on the motion in limine?
Our appeal does not include the ruling on the motion in limine because as the trial unfolded, much of that evidence did find its way into the trial. And what we wanted to focus on in our appeal, what we think is the legal issue here, is whether or not there can be a double recovery. Now, it does dovetail with that evidentiary issue, and that is an issue worthy of consideration under the facts in this case. The cleaner issue is whether or not there can be the double recovery. Our position is, as Your Honor quite articulately stated, is that Cox answers the question. There are four main points that should govern this appeal, and that come out of the Florida Supreme Court's disposition in Cox. The VPL, as interpreted by the Florida Supreme Court in Cox, establishes a liquidated damages provision in the event of a total loss due to a covered peril. In other words, the insured is entitled to be indemnified, and the recovery is established by the policy limits. There's no need for a trial on value. Second point that comes out of Cox is that the VPL does not operate where the property is damaged by multiple perils for which the insured has purchased separate policies. Third point that comes out of Cox.
Let's assume you have two policies, each for $250,000, and the hurricane causes $500,000 in loss attributable to both. Would Cox allow policy limits to be paid under each policy? Would there have to be a determination that it was exactly a 50-50 loss?
It would be apportioned under Cox. It would be apportioned. You couldn't recover the total for the total loss separately under the two policies.
Mechanically, would that really require one lawsuit involving both insurance companies? How do you get there by having two separate claims running down two separate tracks?
Well, you get there by applying an offset. As the trial court recognized in the beginning of these proceedings that this was going to be a legal issue to be dealt with at the end of the day, as a legal issue determining whether or not there should be an offset and to what extent that offset should be applied. Now, in the hypothetical,
and I agree with you. If there had been a determination by the trier of fact that flood caused 50% of the damage, but the trier of fact here found that all of the loss here was caused by wind.
But then the insured is still limited by the policy limits. Under Cox, there has to be an apportionment for that. I want to go back to the hypothetical that Your Honor raised with the $500,000. In that situation, it would seem to me that there was a decision made by the homeowner to be underinsured because neither policy now under the NFIP, the policy has caps, but under the wind policy, there would have been a determination to underinsure that property, and that's a risk that the homeowner would have decided to bear. In Fox, the court clearly stated that
But doesn't the situation here, in effect, they're underinsured here because you have a $400,000 home and you didn't have $400,000 of coverage?
In this case, there was a determination made to cover less than what the homeowner believed was the full value of the home. That's correct. But they're still limited by the policy limits, and they're still limited by the apportionment under Cox. The VPL under Cox is intended only to set the value of the property. It establishes the property's value when there's a total loss, and under the VPL, an insurer cannot challenge the value of the property. It intends that an insurer is liable for a loss by a peril covered under the policy, not a loss not covered under the policy. In this case, we have a determination that the loss, a concession by the homeowner, that this loss was attributable to flood. There was a claim, there was a policy limits played out on the flood, subject to cap, and that's why now we have the issue of the set-off and what portion of the wind policy would remain to be paid to the homeowner. That's why we say that Cox does answer the case. Now, this is, of course, a situation that's unique to a geographic region, which is why we look to the Louisiana cases that deal with similar situation involving similar hurricane and apportionment. But we're not reaching for new ground here by looking to Louisiana because, again, Cox, as Judge Van Orpers, as you pointed out, provides us with the roadmap for resolving the issue. I'm sorry, I thought I was interrupting you.
Go ahead. No, I'm just I've been interrupting you. So.
No, that's correct. The appellees make the point that Florida is not an indemnity state and that we shouldn't be looking to Louisiana case law, which is an indemnity state. Sort of a misleading argument. It's accurate in so far as it goes, but it doesn't explain the full picture. The point is that insurance is intended to be indemnification. Whether Florida is an indemnity state or not, that goes to whether or not we establish values based on policy. We're a value policy state. So we are not an indemnity state. They are correct. But that doesn't mean that insurance is not intended to be indemnification or recover for loss. It also doesn't mean that under Cox you're allowed to recover a double recovery and apply both policies without regard for the direction by the Florida Supreme Court to apportion.
But the issue with set-off here, did you preserve that below?
Well, we have two cases here this morning.
Right.
The one
I
to
may
follow.
be getting them confused because my brain sometimes does things like that.
In both cases, the issue was squarely before the trial court. Let me begin with that, a little foreshadowing of the case to come. In the Mathis case, there was no formal motion to set off at the end of the trial. The issue of set-off came up at the beginning. It came up in the context of the motion in limine. When the judge ruled on the motion in limine, it was then understood, it was then stated, acknowledged by counsel, acknowledged by the trial court, that the issue of set-off presented a legal issue that would be addressed at the end of the day after the trial, that it was a legal issue for the court, not a matter for the jury.
Do you agree, counsel, that the defense of set-off is an affirmative defense?
Set-off is an affirmative defense, yes.
And you make a fundamental error argument.
We do make a fundamental error argument in this case because it's essentially a recovery of damages to which there's no entitlement as a matter of law.
Now, are any of your fundamental error cases involving a set-off under the principle that sort of unjust damages have been awarded?
No, we did not find a case involving set-off exactly. Precisely that deals with fundamental error. Our position is, though, that the set-off in this case is a set-off to which we're entitled as a matter of law under Cox. The failure to do it allowed the plaintiff to recover damages to which they're not entitled, and that is fundamental error. It also came up again as a matter of course in this motion, in the motions in limine. There was no tactical advantage here to not bring it up later. This was not a situation in preservation where it was a gotcha move. Don't raise it later as a gotcha. It's not that. This is a legal issue. This is a legal issue that was going to come to the court either way. If there was the motion for set-off and the set-off was granted, we would have been up here on appeal either way. Technically, was it raised in a motion in the Mathis case? No. As a practical matter, was everyone aware of it? Yes. Was it teed up? Yes, it was teed up in the motions in limine. And again, we rely on the fundamental error.
Counsel, you're under 4 minutes.
Thank you. Unless there's any other questions, respectfully request the court to reverse and remand with directions to apply set-off. Thank you.
May it please the court, I'm Jim McKenzie and I represent the Mathises, and there was a good deal of discussion during Mr. Kula's argument concerning the Cox decision and what Cox holds as far as set-off and double recoveries, and absolutely none of that is argued in their brief at all. The only mention of Cox in their brief is in discussing an incidental issue that we raised in our brief concerning the application of the rules concerning set-off and that type of thing, but they do not discuss it directly ever in their brief, and none of these arguments are vague, and neither does Cox. Cox doesn't discuss the issue of set-off. Cox discussed the situation in which the valued policy law had been interpreted by this court to include any damage done when the structure was a total loss that the BPL had to be paid, whether that damage caused the total loss or did not cause the total loss and did not contribute to it. And the facts in Cox were such that the damage to the house was mostly caused by flood. And we're in a very different situation in this particular case, because in this case the evidence was that the damages were segregable. There was a flood line, and it was not our case in which that was done. It was done in the defendant's case, in the insurance company's case. Their engineer is the one who segregated the damages. He said that everything below 6 feet was related to flood, and everything above 6 feet was related to wind. And we then took upon ourselves the proof of what the damages were above the flood line, and those exceeded the amount of the policy limits, and the jury was...
What were the damages above the flood line?
The damages above the flood line were exterior damages. This was an EFIS type of structure, and there was exterior damage to the EFIS all around this particular house, and the testimony was under...
What's EFIS?
EFIS is an exterior surface that it looks like stucco, but it's not really stucco. It's a kind of stucco type material.
Sprayed on sort of a paint. that goes
Yes,
on.
sir. Well, it's actually done in stages, and we're getting a little technical about it, but there's some, and the testimony was unrebutted that once any part of a wall that has that on it gets damaged, it has to be totally replaced. And there was damage to that on the second floor, and these walls had to be replaced. There was extensive damage to the interior of the house, to all the surfaces inside the house on the second floor. There was roof damage. Obviously, roof was pretty much gone on the second floor in this particular house.
So
there was window
the
damage.
cost to repair that?
Yes, sir. The cost to repair that damage was in excess of $325,000.
And what was the amount of the windstorm?
$295,000. So the damages were segregable. And the real importance of Cox to this case is that Cox makes clear in footnote number 6 in that opinion that I've cited in my brief that when the damage to the structure from wind alone would make the house either a total loss by itself or a constructive total loss, then the opinion in Cox is irrelevant. It doesn't apply, and the VPL is there to take care of that. And that's what we have in this case.
Didn't the trial court here exclude evidence on the damage caused by the flood?
No, sir. There was extensive testimony concerning the damage caused by flood.
What did the motion in limine, the ruling on the motion in limine accomplish?
It accomplished not allowing an adjuster to say flood damages were X dollars because, first, there was no showing that that person is qualified. That's an engineering determination and a construction determination. He's using simply a computer program that he plugs in various things to, and if you go back and look at the evidence, that's what it was. So the court said that's not material or relevant to the issue. So that's but in truth, Your Honor, that's not important because they haven't appealed that. They have not appealed anything other than the failure of the trial court to sua sponte grant a set-off in this particular case. It was not pled by them. It was not raised at any point by them at any point in time. And after the verdict came in, they didn't ask the judge to set it off then. They simply argued that the judge erred in a lot of his evidentiary rulings at the trial of this particular case, and that's what caused that was the error they assigned.
The set-off did not occur until well after the trial. No discussion of set-off was made with the judge.
There was a discussion of set-off of the payments that they had made under the wind policy on the policy limits. Yes, sir. And that's discussed extensively, and we agreed with that. I mean, that's why it was no big deal whether it was pled or not. We knew that was happening, and we agreed with that, and that was the agreement from the get-go. That we were.
The judgment reflected the set-off for the payments?
Yes, sir. So it reflected the set-off for the previous wind payments. But they never raised the issue of set-off of flood, ever, until this appeal. This is the first time we've heard it, is in this appeal. There was no argument about set-off. There was no presentation to the trial judge about set-off. There was no discussion with the trial judge about how the set-off would occur. For instance, Florida is a replacement cost state. And so it's the replacement cost of this house that it really determines the total amount of damages, not some figure chosen by someone in an insurance policy. And by the way, there was a question about the underinsured. My client, the testimony is unrebutted that my client's insurance was determined by Florida Farm Bureau. They're the ones who determined what the policy limits were. And that was uncontested. And that's also really not an issue in this case, but just for general information, that was what the testimony was in this particular case. They determined the amount of the insurance, and they had, and as many policies do now, have some kind of inflation factor that goes into most of the policies, and the policy limits do inch up. But there was no determination. But what the evidence showed at this particular trial is that the replacement cost of this house was in excess of $500,000.
But counsel, even under those facts, if you look at the recovery and the flood insurance policy and the wind policy, those recoveries were far in excess of $500,000, even with the prejudgment interest.
They were $545,000. Okay, is what the recoveries were. Yes, ma'am. They were more than that number that he testified to. But that brings us to the point as to whether Florida applies the indemnity principle to property insurance contracts, and this court has clearly said we do not. And in fact, there are 2 or 3 decisions, one of which is cited in my brief, in which they were allowed to recover from multiple policies on the same risk. In other words, there was one case in which there were 3 separate fire insurance policies on this particular structure, all of which were supposedly for the value of the structure. And the court said, you charge the premiums, you pay the policy limits, because that's what the Florida law is in regard to this. Whether there is a windfall or not is not important.
Well, I think that we have here in this case, the homeowners have received $250,000 payment under their flood policy.
Yes, ma'am.
Shouldn't they be precluded from then claiming that they received a total loss under the VPL?
Well, let's put it this way. Let's say that my clients had received $250,000 worth of damages to the structure from flood, and they received another $325,000 to damages to the structure from wind. Is the wind carrier entitled to offset the flood money against the damages that wind caused? That's where the issue comes down. They charge the premium based upon a certain amount, and the Florida cases that deal with the indemnity rule point that out. They set their exposure with the policy limits, and they charge premiums based upon that. And that's what our law requires them to do, is to pay that if the damages are there. In this particular situation, and we are discussing things that I don't think are really an issue in this case. The real issue in this case was the trial court's failure to do a sua sponte set-off. In this particular case, fundamental error. Well, if it is fundamental error, then all the set-off cases that say it has to be pled and proven, you might as well throw them out the window. They don't mean anything anymore. Those cases clearly indicate that the state of Florida requires that issue to be presented to the trial court, and if it's not presented to the trial court, it is waived. It is waived. So now we're going to let them get around the waiver that this court and others have applied to this situation. If set-off is fundamental error, then there's no reason to have that rule. The rule means nothing. The rule is there, and it's what it is. And they didn't plead it. They never presented it. And now they want you to let them get off the hook because they failed to present it to the trial court. That's not fundamental error, and it's not proper in this particular case. What we have here is a situation where a jury was presented with evidence concerning the losses. There was extensive testimony concerning what flood caused and what wind caused. We proved up the value of what the wind damages were because that exceeded both the policy limits and the value of the house. And the value is a little different thing than replacement cost of the house. And also because it met the requirements of the Santa Rosa County floodplain ordinance that required if it was more than 50%.
Is there evidence in the record as to the appraised value of the house?
No, sir, and there could have been, yes, sir. But there was no evidence concerning what the appraised value of the house was. Well, unfortunately, the way the floodplain ordinance is set up is a little different than that. The floodplain ordinance uses the tax assessor's appraisal, basically, of the structure, and it is only the structure, not the land, that is important under the floodplain ordinance, and that testimony was in the record. They use that to determine the value of the structure. They add 20% to that because there are certain factors that go into the appraisal by the property appraiser's office that are not in your typical value estimate. They remove things that would normally be included in that, and that's why the 20% is added. That's a FEMA rule, and the states and the counties have adopted it in order to be able to be eligible for flood insurance. There is a chance. I mean, the insurance company had an opportunity to prove something differently. They could have had an appraisal of the structure done before the damage was done to it, obviously, on the value before the damages, and they did not present that in this particular case.
Counsel, I realize this issue may not be precisely in front of us here, but I'd like your wisdom on Cox, because as I read Cox, what should occur in a case where you have multiple causes from different perils, flood and wind, on one structure, that there should be some sort of allocation between the two made. which wasn't done here. What is your thought on that?
Your Honor, I disagree with your reading of Cox. Cox was a very simple issue, and that issue was if there's any damage any damage to a structure that is a total loss, if there's any damage to a structure that's a total loss from the covered peril, then is the insurer required to pay its policy limits and under the VPL? And Cox ruled, no, it is not. Cox did not discuss anywhere in that opinion making an apportionment of damages. It simply ruled on that issue. And Cox itself is very limited to that particular issue.
I understand. And I understand what I am asking is, what is the logical extension of Cox? Because those are the cases we're starting to see, is trying to apply Cox in different situations. By their ruling, they left open the question of what happens when you have damage from multiple peril. You couldn't go with the solution that Mirza and our court did in Cox. So where do you go?
I don't know where the Supreme Court's going to go, Your Honor, but I think that
we're going to need to go somewhere first and then let them tell us we're right or wrong.
There is if you look at the 2005 changes to the VPL, and I think you hit on it before when you said that maybe that's what they meant to do. That's not really what they did, but I
understand. I agree they didn't do it, but I mean,
and the question then becomes, but see the language in the VPL and the language which was even less clear about that in the old VPL. The 2005 VPL language indicates causation of the loss. Now, and I think that leaves open a lot to interpretation still, and that law has to be interpreted in favor, I believe, of coverage and of that type of thing. That language leaves open the possibility if you have, for instance, flood damage that goes to, let's say, 40% of the value of the structure, and then wind damage on top of that goes another 40% of the structure, and you have 80% of the value of the structure in damages. What's the cause of the total loss? That's a very difficult argument to make. But if you look at the statute that's now there, and I think by extension, to some extent, causation that they discussed in Cox that was not in the statute, that they implied in it that was not there in the statute, then you look at this situation. I think there's a strong argument to be made that it would not have been a total loss from flood. And therefore, you have a proximate cause type of analysis there that the wind actually brought it over the total loss. Now, the set-off issues need to be determined by the legislature, not by the courts. That's not something that the courts should be doing, because it's not clear whether there's a set-off or not. Because in Cox, the footnote in Cox is very clear, and it says this opinion does not apply if the covered peril alone would result in a constructive total loss or an actual total loss. And that's a very interesting thing, because if you have more than 50% damage to the structure under the floodplain ordinances, and the structure has to be elevated and can't be because of the cost involved economically, then you've got a constructive total loss. Now, do you do that in absentia of the flood damages? I think you do. I think you look at it in absentia. If you would have had a total loss anyway, the flood damages are irrelevant.
Thank you, Counsel.
Counsel, your client did make a claim for flood insurance damage.
Well, Your Honor, my client notified Florida Farm Bureau, who had both policies. And Florida Farm Bureau came out and wrote him a check for the flood policy. Yes, sir.
Thank you.
Thank you.
May it please the Court. Respectfully, what Mr. McKenzie is arguing for is a double recovery, to recover for a total loss under two policies for the same loss. It's precisely what Cox instructs us is not the law. I'd like to read from Cox, because Judge Van Nortwick, you're right on in your reading and interpretation of Cox. And I'm reading from page 820 under head note 5. It says, "We do not find that the plain language of the statute intends that if a covered peril causes part of a total loss, that the insurer is mandated to pay for the total loss." Continuing on further down on the same page, under Headnote 6, the Court continues, based upon this plain language of the statute, we conclude that the statute intends that an insurer is liable for a loss by a peril covered under the policy for which premium has been paid, not for an uncovered peril, a non-covered peril, not for a peril for which insurance has not been purchased. The VPL does not provide any authority for stacking. The language I just read is what, Judge Bernhardt, you're keying off of to see that it is an apportionment. They did not use the term apportion, but they described apportionment. It's the very definition of apportionment. The wind insurer cannot be responsible for a non-covered peril, such as flood. Cannot be a trigger, they cannot argue to be able to trigger a second recovery under the VPL and still remain faithful to the Florida Supreme Court's instruction in Cox. We respectfully request the Court to reverse and remand with instructions to apply a set-off consistent with the Florida Supreme Court's opinion in Cox. Thank you.